Hello and welcome to The Real Beef. I'm Don Keith. Well, President Trump and the Supreme Court are absolutely crushing it today. In a 6-3 ruling in Trump versus CASA, SCOTUS delivered a monumental win for President Trump, curbing federal judges' power to issue nationwide injunctions against his executive orders, particularly his birthright citizenship policy. The sometimes conservative and sometimes not Justice Amy Coney Barrett's majority opinion declared that such injunctions exceed the equitable authority Congress granted courts, ensuring that only plaintiffs directly involved in a case receive relief. This decision unshackles Trump's America First agenda, allowing policies to proceed, reinforcing his executive authority and restoring constitutional balance against all of these activist judges who were using their benches to further a Democrat agenda. This is a big win for conservative principles, prioritizing the separation of powers and the will of the electorate who chose Trump to enact these bold reforms. We didn't elect these rogue judges and corrupt bureaucracies to keep us in some leftist purgatory until they can weasel another Democrat president into place, but that's what they were attempting to do. Activist judges repeatedly violated constitutional principles by halting Trump's agenda. For instance, in February of 2025, Maryland District Judge Deborah Boardman issued a nationwide injunction blocking Trump's birthright citizenship order, claiming it violated the 14th Amendment despite lacking jurisdiction to dictate national policy. Similarly, Massachusetts Judge Indira Talwani's April 2025 injunction stopped Trump's humanitarian parole termination for 532,000 migrants, overriding executive authority with a sweeping, baseless ruling. These actions by unelected judges undermined conservative values of limited judicial power and national sovereignty, which the Supreme Court's ruling today corrects. Now, one of the side effects of today's ruling will be that these nationwide injunctions blocking President Donald Trump's birthright citizenship executive order will go away and the president can get on with his immigration agenda. While not ruling on the order's constitutionality, the 6-3 decision allows Trump's policy restricting citizenship to children of legal U.S. residents to proceed in parts of the country, potentially impacting over 150,000 newborns annually. This is what conservatives voted for: principles of national sovereignty and rule of law empowering Trump to redefine citizenship and curb exploitation of our borders. This is a signal from the court that it rejects open border policies, affirming the executive's right to protect American interests as mandated by voters. Now, these activist judges had previously derailed this policy with their reckless overreach. For example, in January 2025, Washington State Judge Thomas Rice issued a nationwide injunction against Trump's order, falsely claiming it defied the 14th Amendment, ignoring historical context altogether. And what is the historical context? Well, let's look at that. After the Civil War, the abolition of slavery via the 13th Amendment left millions of freed African Americans in legal limbo as Southern states enacted black codes to restrict their rights. The 14th Amendment was crafted to ensure that freed slaves were recognized as full citizens with the same legal protections as white citizens. The phrase "subject to the jurisdiction thereof" was included to clarify that individuals under U.S. legal authority, excluding, for example, foreign diplomats or Native Americans under tribal jurisdiction, qualified for citizenship. The broader context included debates over how to rebuild a fractured nation while safeguarding the rights of newly freed people against hostile Southern legislatures. The amendment was part of a Republican-led effort, of course it was Republicans, in Congress to constitutionalize the principles of the Civil Rights Act of 1866, which had granted citizenship to all persons born in the U.S. regardless of race, but required constitutional backing to withstand potential repeal by future Democratic majorities. And if we look at some of the framers' writings or Senate debates, we can see the actual intent of the 14th Amendment, which was primarily authored by the Joint Committee on Reconstruction, with key figures like Senator Jacob Howard of Michigan and Representative John Bingham of Ohio shaping the language. Their writings and congressional debates provide insight into the amendment's intent regarding birthright citizenship and its focus on free slaves. Now, it was Senator Jacob Howard who introduced the Senate clause, and in an 1866 Senate debate, he explicitly stated its purpose, saying, and I quote here, "This amendment, which I have offered, is simply declaratory of what I regard as the law of the land already, that every person born within the limits of the United States and subject to their jurisdiction is by virtue of natural law and national law a citizen of the United States." He goes on to say, this will not, of course, include persons born in the United States who are foreigners, aliens, who belong to the families of ambassadors or foreign ministers accredited to the government of the United States, but will include every other class of persons. So, I mean, it really can't be any clearer than it's stated by one of the very framers of the amendment that it was never to include tourists who come to America so they can spit out a baby and leech off of the American taxpayer. I mean, so why do we have these rogue judges like Brian Murphy in Boston who blocked Trump's policy and imposed these ridiculous due process requirements, effectively paralyzing deportations tied to the order across the entire nation? But thankfully, the Supreme Court's ruling today dismantles such obstructions and paves the way for Trump's transformative immigration reforms to take root. Now, another great decision handed down today by the Supremes was their 6-3 decision upholding parental rights in education. This will now give religious parents the right to opt their children out of engaging with LGBTQ-related books in elementary schools, which is another resounding victory for President Donald Trump's education agenda. This ruling reinforces parental authority, which is a cornerstone of conservative values, ensuring that families can guide their children's moral and religious upbringing without interference from progressive school mandates and the Marxist teachers with the rainbow flags hanging in their classrooms. This aligns with Trump's pledge to restore common sense and traditional values, empowering parents against ideological overreach in public education. It's a decision that really strengthens the First Amendment's free exercise clause, protecting religious liberty from secular encroachment. And of course, activist judges have repeatedly thwarted Trump's policies relating to this as well. In fact, in February 2025, D.C. District Judge Tanya Chutkan issued a nationwide injunction blocking Trump's executive order to expand parental opt-out rights for curricula involving gender ideology, claiming it violated federal education guidelines. And similarly, in Maryland, Judge Lydia K. Grigsby halted a Trump-backed policy in March of 2025 that allowed parents to exempt children from diversity training, arguing it undermined equity initiatives. These rulings violated constitutional conservative principles by prioritizing bureaucratic agendas over parental rights and religious freedom. The Supreme Court's decision today overturns such ridiculous judicial activism, ensuring that Trump's vision for family-centered education prevails, safeguarding the values of millions of American parents. So that's the basic breakdown of what happened today with the Supreme Court, and hopefully there will be more wins to come. But I want to thank you all for watching, and don't forget to hit that follow and like button before you go. We'll see you next time.